Got people joining. That's great. Well, we're just getting to the top of the hour, so why don't I kick us off? Welcome, everyone. It's really nice to have you all here at the World Trade Center and Colorado Office of Economic Development webinar. Uh, we're kicking off this series. This is the first of a series of programming called the Tariff Navigation Program. So welcome to our official Tariff Navigation Program. It's a series of webinars brought to you by the World Trade Center Denver and the Colorado Office of Economic Development and International Trade, or OEDIT. And it's all through the state's Economic Resilience Technical Assistance Program. So thanks to the governor for kicking this off. We are collaborating with OEDIT on this program, and it's very nice to partner with you. This series of 6 webinars and subsequent direct trade support services provided by the World Trade Center Denver include practical guidance on sourcing, classification, compliance strategies in response to new and existing tariff regulations. So please mark your calendars for our next webinars for the upcoming topics that interest you. They're on the screen, and you'll see that we've got some great topics lined up for you. So now we understand how difficult it's been this past year to manage your risks and costs when the rules of the game keeps changing. There certainly may be more ways to mitigate some tariffs, or at least better plan for them. And so that's what we're here for. The World Trade Center Denver has supported thousands of companies with imports, exports, trade compliance, supply chains, and enhancing global operations for nearly 40 years. But over the past year, we've helped hundreds of companies directly with tariff solutions at the short, mid, and long-term timeframes. So World Trade Center Denver is a nonprofit 501c3 trade association, and we do need to charge base fees for some of our consulting services. But OEDIT is offering up to $1,000 matching reimbursement grant, up to a total of $20,000. So first come, first serve. And this will be until August 17th of this year. And we're offering this to qualifying businesses to offset some of the service fees that the World Trade Center may need to charge to deliver our services. So the qualifying criteria for companies to be qualified for this reimbursement grant is that you need to be operational for 3 years or more in the state of Colorado. Attend at least one of the tariff navigation live seminars or webinars that you see on the screen. And since you're here, you qualify. Qualify as a producer, which is basically a manufacturer or an importer of goods, could also be a distributor of goods. And you must agree to share some impact data on the services rendered. So in order to schedule your initial discovery call with us to assess your company's needs and to just develop a customized support plan for your company, please complete our request form, and we'll be putting a link to that in the chat so you'll be able to see it. At today's webinar, if you do have questions for our expert, I would ask you to put those in the Q&A session so we can facilitate those out at the end. So I didn't introduce myself. I'm Karen Gerwitz. I'm the president of the World Trade Center, and it's so nice to be with all of you. I'm really looking forward to today's session because we've lined up one of our favorite experts here, Kate Rayer, and she is a licensed customs broker from a World Trade Center member, Green Worldwide. Kate is the vice president of regulatory services at Green Worldwide, and she's got a dynamic trade compliance background with 20 years of global supply chain experience. She's super knowledgeable. Plus, she takes the complicated and turns it into language we can all understand. So, Kate, it is so wonderful to have you here, and your expertise gives us a source of calm. So, thank you for being here, and I will go ahead and turn it over to Kate so she can share her slides and get started today. We'll come back to you afterwards.
Awesome. Thanks, Karen. Really appreciate the intro and for having me here today. It's always great to see an audience and talk through what's going on because, the last, 14 months now have been quite a wild ride. So what I'm going to do today is just walk through what is going on right now, talk through what we think might be going on in the future, and also give you an idea of what's going on with the refund situation. So I know that's everyone's favorite topic is where's my money, where's my refund. So I do want to just provide you with some updates on that and what the process is looking like today. So that being said, here is what we're going to cover. So we're going to cover tariff tools and enforcement authority. So in other words, what legal tools the administration has available to impose tariffs and why that distinction matters more now than it has in a long time. And then we'll talk about IEEPA, where things stand with the Supreme Court developments, get into talking about Section 122, 232, and Section 301. These are all different trade tools, and I want to talk about, what's going on with current investigations, how these might play out in the future, and how they interact together. And then we'll do a general trade update with, what's going on with each partner country that we're trading with, and policy-driven updates there. Then we'll get into the IEEPA refund discussion. And then last up, I'm going to just walk through some general information about entry timelines, and I'll show you a practical example of how this works and why it's important relative to the refund conversation. And the last thing I'll cover is, some practical advice for what importers should be considering doing now from a risk compliance strategy standpoint, given all of the things going on, the legal uncertainty and the pace of the policy change going on. Just an important disclaimer, nothing I am covering today is going to be considered legal advice. This is all informational. So we all know this is moving fast. This information is current as of today, but as we have all seen, that could change tomorrow. And last thing, there really is no one size fits all answer when it comes to, your company's trade policy strategy. So with the information I'm providing, take that as you will. Discuss with Trade Council as necessary, because again, this is a very fluid time. Okay, oh, too far. All right, so let me just get situated here and then we'll get into the details. Okay. All right, so what you're seeing here today is there's a lot to unfold with the different trade actions that are going on. And I want to talk through the main legal tools that Congress has delegated to the president to potentially impose or adjust tariffs. So each of these sections, they originate from different trade laws. They each have unique triggers and limitations. Some may be familiar to us, while others, have historically not been used to implement tariffs before. So starting with Section 232, this is a national security tariff. It allows the president to impose tariffs when imports threaten national security. This authority requires an investigation by the Department of Commerce and gives the president broad discretion once a threat is found. Section 232 is regulated under the Commerce. There is no tariff duration limit. There is no tariff rate maximum. So this one, it's really used mostly in a sector or product specific way. So some tariffs that we have seen come out of 232 include tariffs on autos, auto parts, steel, aluminum, copper. Those are some of the more recent prominent examples. And I will talk a little bit more about what the future looks like with Section 232 here in a little bit. Section 301, hold on one second. Section 301 empowers the U.S. Trade Representative to respond to unfair trade practices or violations of trade agreements. So this one we have seen used as a primary tool in the trade war with China. Particularly during the first Trump administration, we saw this one used pretty broadly. It does remain central to enforcing our trade commitments. And recently we have seen this one be utilized with investigations with both Nicaragua and Brazil. Section 301 is under the USTR. There is a tariff duration limit for Section 301, which is 4 years with unlimited extensions. And with this one, there is no tariff rate limit. And I will talk more again about what the future of this one looks like because there has been some updates with Section 301 very recently. IEEPA, as we all know at this point, this is the International Emergency Economic Powers Act. This one is triggered in response to a declared national emergency to foreign threats. As we know at this point, this one has been ruled that tariffs are illegal if used under IEEPA, and we will go more into that a little bit later on. Section 201, this one is about safeguards. So it allows temporary tariffs or quotas really to protect a domestic industry from a surge in imports. So this is a safeguard action that has been used historically for products like solar panels, washing machines, as recent examples. These measures, they are time limited, and really what they're meant to do is to give U.S. producers some breathing room to really adjust to the surge in imports. Section 201 is under the ITC. It can be used for 4 years with a 4-year extension and does have a tariff rate maximum of 50% with a phase down being required. Section 122 is our new one. The same day as the Supreme Court struck down IEEPA tariffs, we saw Section 122 tariffs come into play. This one is about a balance of payments issue. So it's meant to address, say, an international payment imbalance. Really, it's never been used to implement tariffs before. It's really meant to address a very narrow economic situation. It's not under any agency, and it can only be used for a brief time of 150 days and does have a tariff rate maximum of 15%. I will get into more about, whether this Section 122 is legal as well a little bit later in the presentation. Section 338 is another tool in the toolbox. This one is really about discrimination against U.S. commerce. This one empowers the administration to respond when a foreign country or its nationals engage in discriminatory, maybe unreasonable trade practices. Again, this one has never been used to impose tariffs, and it does remain as a dormant tool in the toolkit. So we might see this one be used in the future, just depending on what goes down the next few months here. But as of now, this one has not been used for tariffs. And I put another one on here. This one's really recent. So there's currently an investigation going on with the USITC that is considering removing China from its permanent normal trade relation status. What that means is that there's an investigation going on to potentially change imports from China from the column 1 general duty rates to the column 2 duty rates. So China was first granted this PNTR status back in 2000 when it joined the WTO. So this one will be interesting to follow to see how this plays out. But I did want to bring this to light that this is currently being investigated as a potential in the future. So taken together, these statutes, they give the administration a variety of different levers when it comes to trade policy. Some are frequently used, some are more, symbolic in nature. They create flexibility in U.S. trade policy without waiting for new legislation. The legality of these, again, are being tested. As we saw with IEEPA, that one was ruled illegal. We'll see how Section 122 goes, but really this is meant to give you more context for what all is going on. All right, so getting more into Section 122 and what's going on with that. So at a high level, again, IEEPA tariffs are no longer being collected as of February 24th. That was a direct result of the Supreme Court decision. Instead, the same day, now we have Section 122 tariffs. Those took effect on February 24th as well. Some important technical points about Section 122. So many of the existing reciprocal tariff exclusions that were in place will continue, meaning if you were already covered by a valid exclusion to these tariffs, you're likely going to be excluded from Section 122 as well. Canada and Mexico origin goods are exempt from Section 122, just like they were with IEEPA, provided they are qualifying under USMCA. Section 232 derivatives look like they're getting the same treatment under Section 122 as they did with IEEPA. And one of the bigger questions that, came out when this all changed from IEEPA to Section 122 was what happens with all of the trade deals that were negotiated under IEEPA? For example, there were deals with the EU, with Korea, with Taiwan, with Japan. And right now, it looks like these deals remain in place. However, the tariff treatment has changed slightly. So, for example, with the EU, with the IEEPA tariffs, there was a tariff rate maximum of 15% for the reciprocal. With the new tariffs of Section 122, this is a flat 10% on top of the general duty rate. So there is a slight shift there for countries that did have those specific trade deals and tariff rate maximums. For foreign trade zones, privileged foreign status is still required under Section 122. And they are, then that means they will still be subject to the Section 122 tariffs upon withdrawal from the foreign trade zone. An interesting tidbit here that I did want to point out for FTZ operators is that if you did have merchandise that was admitted to an FTZ in the time of IEEPA tariffs, those tariffs are no longer being collected at the time of withdrawal. So what that means is even though, privileged foreign status was elected at the time of admission, at the time of withdrawal, IEEPA tariffs are no longer being collected. For bonded warehouses, those continue to be subject to the rates in place at the time of withdrawal. Again, the rates for Section 122 are currently at 10% for all countries. Okay. This is going to be, it was originally supposed to be 10, and then there was an announcement that it was going to be potentially 15. At this point, that has not come to fruition. We have heard that it may happen and it may happen soon, but at this point, there has been no timeline announced as to when that might go from 10% to 15%. There was a short in transit exemption for Section 122 tariffs that window has now closed. But if you did have, merchandise that was in transit during this transition time, there would be a potential that they could qualify for an in-transit exemption to both tariffs. Again, FTZ admissions are required in privileged foreign status, and duty drawback is available for Section 122, which is great. One little nuance to consider there, the difference between Section 122 and IEEPA is that now exports to Canada and exports to Mexico are eligible for drawback where previously they were not under the fentanyl tariffs. So that's a bit of good news for exports to Canada and to Mexico.
Hey,
Okay.
Kate, before you move on, we do have
Sure.
one person raising their hand,
Great.
but I would ask you guys to try to put your questions in the Q&A if you could. So, Samuel, if you wanna, we can unmute you or you could jot it into Q&A and I'll make sure Kate sees it. Um, Hang on a second, let me see. Yes, if
Problem.
you could just jot it in Q&A, that would be great. Thank you. Sorry about that.
No problem. So I just want to take a look now at, is the situation better under Section 122 versus IEEPA? And the answer to that question is maybe. It depends. So on the left here, you'll see Section 122. And for Canada and Mexico, I see this as a net positive, right? The tariff rates have been reduced for Canada and Mexico, and these are now drawback eligible for exports. So that's a win for the time being. China, their rates are significantly lower under Section 122 than they were under IEEPA. Indonesia, much more favorable. India is much more favorable, and so is Brazil. For the countries that did have these trade deals negotiated, the answer to these questions is it depends. It depends on the general rate of duty assigned to that product, whether or not Section 122 ends up being a better outcome or if IEEPA was a better outcome. An interesting note here is that when we're in this period of Section 122, there is some dialogue going on with all of these trading partners, that, they were trying to move forward with finalizing all of these deals, formalizing all these deals. And at this point in time, this has been paused. So, for example, the EU Parliament, they held up the ratification of the US EU tariff agreement due to the Section 122 changes. For the UK, right now, it's the same, right? So there was a 10% tariff under IEEPA, and again, now under Section 122, there's still a 10% tariff. So there's going to be some more things that need to shake out, I guess is the point of this, right? Is that these trade deals are obviously still very important, right, to our economy, to the economies of our trading partners and allies. These countries are seeking confirmation that these deals will remain in place. But there is still a lot to go to figure out exactly how that's going to play out. Okay, so talking a bit more about Section 122, what we may see in the future with this one. Again, this is the tariff tool that's being used right now, that's meant to address a balance of payments crisis. That's the legal hook that the administration is using for this action. The core question is, does the US actually have a balance of payment crisis that justifies using this authority? And that really is the issue that is going to be the central focus of any court challenges that come up. I fully expect that these are going to be challenged within the Court of International Trade. The legal theories behind that challenge will look very similar to what we saw with the IEEPA litigation, focusing on, statutory authority and limits. Again, by statute, these tariffs can remain in place for up to 150 days. And one of the big open questions is whether these can be extended, and if so, on what legal basis. So from a practical standpoint, litigation is, if it happens, which I expect it will, it's unlikely to be resolved before these tariffs lapse on their own. The courts, they just simply do not move that fast on these complex trade cases. So really, there may be a path to refunds for these in the future, but obviously there's a lot to go on this. And again, I do expect that these will be challenged. Okay, so looking at what's going on with Section 232 investigations. So again, Section 232, these are sectoral investigations. These have been a favored tool of the administration, and these are on the national security basis. So we have seen some of these move into tariffs, which has been, our steel, our aluminum, copper, timber. There's been several different sectors that have moved into the tariff phase, but these are the different commodities that are currently being investigated under Section 232. So we've got pharma, we've got processed critical minerals, we've got commercial aircraft and jet engines, polysilicon and its derivatives, unmanned aircraft systems and parts, wind turbines, robotics, industrial machinery, PPE, medical consumables. And there's been some new ones announced recently, including energy storage, battery inputs, large-scale batteries, plastic piping, etc. So the point in showing this to everyone here is that there's a lot of movement happening within Section 232 and different sectors being investigated related to national security. It's important to note that not all of these are going to result in tariffs. But once a sector is in the pipeline and under investigation, the trade remedies, they really are a real possibility. So the practical takeaway here is that if you source, manufacture, or you are in any of these markets, it's a good idea to start mapping your exposure, understanding, what is exactly being investigated in these different industries. Participate in these investigations if it makes sense. There's generally, comment periods, things like that. But again, the Section 232 tariffs are remaining to be a favored tool for trade remedies at this point. Okay. And about Section 301, because this one is now becoming a more central focus again. It was a favored tool during the first Trump administration, and we're seeing it come back into play now as well. So on February 20th, very suspect timing, as the same day as the Supreme Court announcement. There was an announcement by the USTR that they plan to initiate different Section 301 investigations. So these were the focus areas were on industrial excess capacity, forced labor, pharmaceuticals, discrimination against U.S. tech and digital services, digital service taxes, ocean pollution, things like this. What the announcement said is that these investigations will be accelerated. And if unfair practices are found, tariffs are a possible remedy that would be used. Now, how this works in reality, typically a Section 301 investigation takes about 6 to 12 months to complete. 90 to 120 days is the common fast track timeframe. So that, we expect that these will follow that fast track timeline. As part of these investigations, there is a comment period, which usually is about 30 days, and also usually includes a hearing. And the USTR, what they're doing is they're assessing economic harm. They're going to be consulting with the foreign countries before they make any policy changes. But if you follow along with the timeline here, the accelerated timeline, I'll show you an example of how this fits into the July 24th deadline. So if we work backwards from July 24th, to have Section 301 tariffs ready by the time the Section 122 tariffs expire, there's going to be a fast track of these investigations. So to bridge this gap, 301 investigations would need to be launched by March and April. They must be in comment period and consultation mode in April and May, and findings and tariffs would be targeted for June or July. So if you follow that working backwards, the idea here is that Section 122, again, is the bridge between the reciprocal tariffs under IEEPA and potential Section 301 tariffs. So what we can expect here is that we would see multiple 301 cases. They would be focusing on excess capacity, subsidies, forced labor, digital trade, pharma, industrial. And again, the goal here would be to replace Section 122 tariffs with more longer living Section 301 and 232 tariffs. So funny is that just following that timeline, we do have new investigations that have been launched since that February 24th announcement. So there's two of them. One is going to be focused on structural excess and capacity in manufacturing. So at a high level, what's being investigated here is that certain countries, including China, the EU, Singapore, Switzerland, they may be maintaining industrial policies or subsidies that encourage production levels that are beyond global demand. So when this happens, the idea is that it can distort local markets, it can push prices artificially low, and put pressure on manufacturers in other countries, including the US. So this investigation is broader than some of the previous trade actions under Section 301, where there's 16 different countries being included, again, including China, EU, several Southeast Asian countries, along with Japan, Mexico, and India. And again, the idea here is that this is not just one product, this is not just one industry, but it's looking on whether government policies are systematically creating overcapacity that can impact global trade. So from a timeline perspective, public comments on this one are due in less than a month, right? So this is moving very quickly. So they are due on April 15th and the hearings begin on May 5th. Again, the potential outcomes here are tariffs, quotas, trade restrictions, negotiated remedies, etc. The second Section 301 investigation that has been launched is on a failure to address forced labor. Okay, so this one is about whether foreign governments are doing enough to prevent forced labor within their supply chains. The key question being the one that USTR is examining is whether certain countries have failed to prohibit the import of goods produced with forced labor. From the US perspective, if these goods are allowed to circulate internationally, it can create an uneven playing field and place US companies at a competitive disadvantage. As many of you may know, the United States has taken a very aggressive stance on forced labor in recent years. This is under the UFLPA or UFLPA. And what it appears the USTR is doing here is that they're extending that pressure internationally by encouraging other countries to adopt similar import restrictions. So again, this one's looking at several different factors, whether or not countries have laws banning forced labor, whether those laws are actually enforced, whether forced labor can still enter into the markets, and whether those goods can circulate through global trade. This one is also quite broad. There's more than 60 countries currently in scope, including major trading partners like the EU, Canada, Australia, UK, etc. Again, this one is moving very quickly. Public comments are due April 15th and the hearings begin April 28th. Similar to the other investigation, the potential outcomes include tariffs, trade restrictions, other remedies. And again, the idea is that we intend to pressure countries to adopt US-style forced labor enforcement regimes. Okay, more about IEEPA and the refunds. I know everyone is very anxious to understand what's going on with this. So on March 4th, the CIT ordered CBP to start issuing refunds. Very shortly after that, CBP came back and said, hey, there is no way we are prepared to do this without standing up some infrastructure to facilitate that process. They estimated that to do this without setting up more automated processes would end up accounting for over 4.4 million different staff hours. So quite a significant lift on the CBP side. So the Court of International Trade then understood that fact. They put a pause to the order to allow CBP time to build this new system to administer the refunds. So what CBP has said now is that they are standing up this new system, and what they're calling it is CAPE. The acronym is Consolidated Administration and Processing of Entries. This is the system that will be used to automate the refund process for submitted claims. So the process is going to have 4 different steps. One being that if you are going to be requesting a refund, that you upload a CSV file within the ACE portal to say, hey, these are my impacted IEEPA entries. These are the ones that we're going to be requesting a refund for. From there would be a mass processing of these claims. They would be recalculating the tariffs owed to the duties owed on an entry by entry basis to remove the IEEPA tariffs, recalculate the final amount due, and begin facilitating that refund back. The next process would be there would be a review, and then they would be reliquidating entries or liquidating entries without IEEPA tariffs on them. And from there, they would be aggregated and the refunds would be issued back to the importer of record. The key point being here is that this is not an automatic process. There is going to be involvement required from the importer and or customs brokers to request the refund, to submit the file, make sure it's accepted, and then the claims themselves must be submitted in ACE. Okay. And what we understand from the timeline right now, which is of course fluid, is that this claim portal will be available in ACE in mid-April. That is the current timeline. And as of yesterday, CBP announced an update on where they're at in setting up this automatic system called CAPE. So right now, again, CBP is under court supervision to provide updates. So they have been providing weekly updates on their progress. And as of now, for the claim portal, they're at 73% complete. For the mass processing process, they are at 45% complete. For the review and liquidation, they're at about 80%. And for the refund mechanism, this is about 63%. So again, it's a little bit slow moving, or it appears to be, from where we were at last week to where we're at this week. But again, is what the estimation is that the realistic date is going to be mid-April for this to be available to submit refunds. So, what should companies be doing now? The most important piece that you can be preparing for right now is to evaluate your entries that are subject to IEEPA. Audit them, make sure that they're correct. It's really important to understand the overall IEEPA exposure in your entry universe and plan for the right mechanism to secure your refunds. Leverage your data. Make sure your ACE portal is active if it is not. Recently, CBP has announced that and mandated that all companies need to be set up for ACH refund. ACH refund means that at an importer level, you're going into your ACE portal and you're setting up your banking details within the portal. CBP is no longer issuing checks. Okay, so they have said unless you have a specific waiver, you need to have ACH refund set up to facilitate a refund. So if you have not done that step, that should be a very important high priority step to get set up if you're expecting refunds. Within the ACE portal, there are a variety of different reports that can be ran to help understand your IEEPA impacted entries. So those reports include entry summary reports, liquidation reports, and here on this slide, I put the specific report numbers. So pull those reports, understand what you're looking at to make sure that you are prepared for the different refund processes that are going to be coming up. Again, ACH refund. I feel like a broken record, but it's so important that if you are trying to get a refund and you're requesting a refund, that you have a way for that money to make it back to your bank account. Okay. It's also very important to make sure that all of your records are complete and compliant. CBP will be reviewing these entries that you are submitting for refund requests. They may be requesting documentation. They may be wanting to know more about, your specific entry, specific products. So making sure that your records are complete and compliant and audited, maintaining proof of payment. These are all vital steps that you can be taking right now in preparation for what's coming. Other things to keep in mind is that CAPE, the process for refunds, as we understand it right now, is not going to be available for every single type of entry. It's not going to be available for entries in every specific time frame. So there may be, a multi-pronged strategy that needs to happen depending on your particular entry universe. Okay. So if you have some older entries that have IEEPA on them, you may want to consider filing protests for these entries. That's a separate legal document that you would file with CBP. Many companies, I think over 2,000 now, have filed suit with the Court of International Trade. This may be a prudent step, something that you definitely should discuss with legal counsel and decide if that's something that is right for your company. Follow these updates closely for CAPE. As we know, this is a brand new system that CBP is setting up. They're trying to do this very quickly. So just staying aware, staying in touch with what's going on with that. If you're expecting refunds is very, very important. As of right now, it is unclear whether CBP will be acting on any post-summary corrections for IEEPA refunds. I am not aware of them granting those at this time. And also CBP has been refusing to extend liquidations for IEEPA tariff reasons. And then the last thing I want to cover is just some really important dates when it comes to entries. So I've said the word liquidation several times, and it's really important to understand why that is important relative to your particular entries and also relative to any particular refund processes. So starting to understand what the entry date is. This is also known as the time of entry. So this date is defined as the time the entry summary is filed in proper form with estimated duties attached. Okay, that kind of starts the process of your whole timeline. Liquidation, what that means is this is the final computation of duties on entries for most consumption or drawback entries. Generally speaking, liquidation happens on or around 314 days following your entry date. Okay, and that liquidation date impacts whether you can file a post-summary correction on your entry. It impacts whether you can file a CAPE refund request. It impacts whether you can file a protest for your entries. So when we're talking about running ACE reports and understanding your entry dates and understanding your liquidation dates, that's the reason why, is because all of these dates relative to your particular amounts of refunds that you're trying to request is a very important date, because if you miss deadlines for these things, generally speaking, you could miss an opportunity for a refund. And just for more to define a post-summary correction and a protest, a post-summary correction, this is going to be a replacement of an entry summary before liquidation. So this is a pre-liquidation tool to correct an entry. Again, for refunds, we don't know if this is going to be a mechanism that can be used to request these refunds. At this time, no. And a protest, the difference in this one is this is for post-liquidation corrections. And protests can be filed up to 180 days past. So again, one's pre, one's post, and you could have entries within your entry universe that require different mechanisms just depending on where they sit relative to those entry dates. And last up, this is just an example of the entry timeline. So in this example, if you had a customs entry that was made on January 10th of 2026, your entry summary date would be approximately January 27th. Your estimated last date to file a post-summary correction would be in November, and your estimated liquidation date would be November 21st, and your last date to file a protest would be May 20th. So that's kind of just to understand the timeline of how things work relative to when you can request different things to try and get those refunds back. So I just wanted to define those so that way when you are looking at that data, if that's something you're doing as an exercise, you kind of understand how those all play together. That being said, that is all I have. I try to leave enough time for some Q&A here at the end. I'm not sure, I have not kept an eye on the chat at this point, but are there any questions that I can address?
Yeah, Kate, I have one. It's a stacking question.
Okay.
You mentioned that if you're paying 232, you don't have to pay 122. But what about if you're
Potentially.
paying 301? Do you have to pay 122?
Yes.
Um, okay, you do.
Yes. So
And you said
301 and section
potentially on the
122.
first
Yeah.
one.
Yeah. And just to clarify the nuance between section 232 and section 122, it depends on your commodity, whether or not you can split out the value of just the, say, steel and aluminum content or not. So there is a little bit of nuance just depending on the type of Section 232 tariff it is and whether or not you can potentially split out values and how those stack. But in general, if you are paying Section 232, you are not also paying Section 122.
And then if you are paying 301, you still have to pay 122.
Correct.
Okay. And then where is the CSMS that shows how 301 and 232 interact, in quotes, with 122?
Oh gosh. I mean, there are so many CSMS messages. I could definitely look all those up if necessary. But in general,
Seems like that's more technical. Okay.
that it's a very technical question, but in general, where you can see where all of these things and how they interact with each other would be within the executive orders, the Federal Register notices, and the CSMS. Taken together, they all provide a more broad picture of exactly how these things play with each other.
Okay, perfect. Um, we also have another one that says if this person recognizes they may have missed the answer, but if an entry with IEEPA tariff on has liquidated,
Mhm.
is protest a valid mechanism for refund?
It could be. It could be. So there is a potential that if they have liquidated that you can still file CAPE. But it's only for a certain period of time post liquidation, which is, as I understand it right now, there may be more information that comes out that clarifies this further. But my understanding is that CAPE will be available for entries that are up to 90 days post liquidation, potentially a little bit less depending on CBP processing time. But again, this is very fluid and there is more information that needs to come out and guidance that needs to come out to further confirm that. But that is my current understanding.
Okay. Um, People are asking if they can get a hold of these slides. They're very helpful. Great visuals, Kate. I don't know if
Sure.
you're comfortable with us sharing
Yeah,
those.
absolutely.
Okay, perfect. We'll also recording this, so we'll have this recording up probably on our YouTube channel. More details will be shared with you on that. So we also have some other offers to help companies to support with this, which I hope you'll reach out to the World Trade Center because we are the network of trade professionals that really come together and support members supporting members, and that's what we believe in. So please get in touch with us, and we'll make sure you get plugged into this program and others. So At this time, Kate, I want to thank you. This was fantastic,
You're
and
welcome.
you're such a good you explained this so well, and I so appreciate your time. I know how
Of
swamped
course.
you are, so let
No,
me
no
just give
problem.
you my sincere thanks.
Yeah.
Now I'd like to turn it over to Emma Howard with the Office of Economic Development, just to say a few words about this program and others.
Thank you, Karen. Thank you so much, Kate. This was so helpful. I hope that the businesses online are able to take away some insight on navigating the current tariff ecosystem from this. And like Karen said, utilize the other programming that my office, the Office of Economic Development and International Trade, and the World Trade Center Denver have partnered on to create. Again, as Karen said, this program was really born from an executive order from the governor's office. He asked the Office of Economic Development, we call ourselves OEDIT for short, to study the impact of tariffs on Colorado businesses, identify areas where businesses are having challenges, areas where businesses may be succeeding, and to identify any programs that we can uplift to mitigate some of those challenges that we identified. And that's again what this program was born out of. So we have these online trainings. This is the first of a series of 6 trainings that are available. So please make use of those. And of course, as Karen mentioned as well, we have one-on-one expert support available at a subsidized cost through World Trade Center Denver's experts. So for businesses that qualify for that program, I highly recommend taking advantage to reduce any costs to ensure that you're in compliance, and to work with the experts that WTC Denver has on hand to really understand what's going on as this tariff ecosystem continues to change rapidly, as Kate has shared with us today. Um, I also wanted to share the report that our office put forth as a result of our research, but it doesn't look like I have the capacity to send messages. So I will just say that if you all look online for the OEDIT tariff report, you can see more information on the interviews we conducted, the data we collected, and the impact that we're seeing on Colorado businesses. And that was all conducted last fall. So as you can imagine, there's quite a bit of updates and increased impact than even we saw about 5 to 6 months ago. I also want to share that part of the response to the governor's EO OEDIT is also amplifying our general business advising services. So while WTC Denver will be offering very specific international trade support, supply chain management, trade compliance, and businesses that engage in that program will get real deliverables as a result of their work with WTC experts. We, of course, still have one-on-one, no-cost business advising available through our small business development centers for general business resiliency, regardless of the economic uncertainty that you may be facing, what the cause of that is. We have one-on-one advising available with business advisors who exist across the state and can support you in creating a more resilient business as we continue to face economic uncertainty, natural disasters, inflation, energy price increases, and all of the other things that are coming down the line and affecting the ability of our Colorado businesses to be successful. So we're really excited about the opportunity to support businesses through this challenging time. And we're so grateful to the World Trade Center Denver and partners like Kate who can help guide businesses through this very challenging and confusing period in our business ecosystem and our trade policy world. So thank you so much all for coming, and to World Trade Center Denver and to Kate for your expertise and sharing that with all of the participants here today. And I believe I am kicking it back over to Sandy.
Yes, thanks so much, Emma. It's so great for the World Trade Center and the Office of Economic Development to be working together on, again, providing resources to our small businesses and our community, like Kate, one of our resources. So, again, I want to say a big thank you to Kate. As Karen said, you really bring a calming effect on a very complex topic, U.S. trade policy. And I just wanted to, again, say thank you. I do want to just make sure, since we, for some reason, aren't able to share in the chat, I do want to make sure people know how to start engaging if you're interested in applying for those funds for direct services, if you really want some additional direct support for thinking through your tariff strategy, again, the first step to engage the World Trade Center to get connected to our expert network and experts like Kate, go to our website. And on that website, you'll find a form on this Colorado Tariff Program page. Fill out that form and let us understand what issue you might be having right now, or what problem you want to solve with your tariff, and we can start helping you build that tariff strategy. So I want to encourage you to go to the website. We will follow up this webinar with information. We will send out Kate's PowerPoint presentation. We'll send out information of how to get involved in this program, and the governor's report that Emma just talked about. It's really interesting. So that being said, I just want to thank you all for spending the morning with us and learning a little bit more about the tariff situation as it is today. And reach out, please, if you have any questions. And thank you again. Hopefully you'll join us for our next session on April 3rd. Thanks so much.
Thank you.
Hey.